Good morning, Samson, and good morning to my seniors on the panel and your viewers. I was actually, or I've been, should I say, shaking, listening to all the views and all the things that have been said concerning this exercise. I was actually hoping that Dr. Shribo would have spoken to try and let us attempt to offer an explanation as to why they, 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 they have chosen the route that they have. Because like you have said, in line with what has been accepted, if you take Article 45, I'll rather start from 42, which is the Ten Hadi emphasized it, that every citizen of Ghana above 18 of sound mind has the right to vote and is entitled to be registered. And so the registration exercise, which is in line with Article 45, I think A, to compile the register of voters and revise it at such periods as may be determined by law. And so obviously read in consonance with the LI, it seems to give the EC the discretion. But discretion, as we know, once it's given by law, cannot be exercised capriciously or arbitrarily without taking into consideration the interest of those that are entitled to benefit from the exercise of that discretion.
In fact, in Tenade, the court said the EC should desist from arbitrary, unreasonable, inflexible registration procedures that disenfranchise eligible voters.
Exactly the point I was driving at.
And it should be inclusive rather than exclusive.
If you look at Article 23, and then if you look at Article 296, it states there very clearly that once you have that discretion to exercise any power vested in you in this context by virtue of Article 45, it should not be done in a manner that would be capricious or will not be beneficial to those that are entitled to or that are intended to benefit from the exercise of that discretion of that authority. Now, from all the evidence that we have before us, it seems that this may be the first time, at least in recent memory, that the Electoral Commission has decided to restrict the voter registration exercise to very, very few centers. I do not know why that they are doing that.
They've used this before, except you said recent memory. So you go on. The EC boss is EC Director of Elections is here. He will help us with some explanation to that.
Yeah, in recent memory, in the sense that in 2016, I don't think that they used, because you read the statement by them. So if we are supposed to be progressive, and then in 2016 we open up the centers with a view of making it more accessible, because civil society and people had complained the manner in which people end up being disenfranchised because they did not have the opportunity to register due to all the limits that come with it. Then it seems to defy all reason and all the efforts and all the gains we have made in such attempt, or in an attempt to bring the democracy to the doorstep of those that are entitled to participate in that process, by limiting it. Like perhaps maybe the EC has reasons, that is why I'm saying that I'm here to hear, which may in the long term allay all the fears, because as it stands now, tensions are very high, because this is a very critical election. Both parties, or two major parties, and all the parties that are interested would want to be sure that their supporters are not disenfranchised. Now, what I was thinking of throughout this process is the role of, is it IPAC they call it? Whether or not the Electoral Commission discussed this process thoroughly with the members of the IPAC.
So they report that it was discussed, but it was not conclusive, and that the EC had told them that it will hear from them. The next thing they heard was the announcement and advertisement.
So that was what I was going to, that if the EC wants the IPAC not to be just a mere rubber stamp, but is supposed to gather or garner consensus on some of these very sensitive and essential democratic exercise, then they should be respecting the views, legitimate views of members of that IPAC. Because if these views were handled, or these things were handled at that level, the EC addressed the concern the concerns that were raised by, because the persons that have sued the EC are members of the IPAC or supposed to be members of the IPAC. I'm not sure if the NDC has gone back to join or participate, but if these things were addressed at that level and what was rolled out satisfied all these concerns, we will not have this hula baloo about this exercise, which will now affect the credibility of the Electoral Commission. And as we are seeing, even the credibility of the officers of the Electoral Commission comparing to what they have said in the past. And it doesn't augur well at all for our democratic dispensation.
Okay, so deal with this, about this with us, and then you can take leave of us. We understand that your time too is very critical to you right now. So the 5 political parties filed a writ in the Supreme Court. Unfortunately, they couldn't get a return date for an injunction application, but subsequently they got it. I think that is now slated for the 17th of October or so. I suppose they would have served that on the EC by now. Then 2 individuals also issued originating processes in the High Court and also got filed injunction applications which they have served on the EC. The EC appears, from what we have seen so far, to have ignored the pendency of those applications and started the process. We understand that there is now a process of contempt that is being pressed. Educate our viewers and listeners. Was the EC's hands stayed once it received the injunction application?
Well, I think there are 2 processes that you are speaking to. You are speaking to the Supreme Court process and then the High Court processes. That is my understanding, that the High Court processes where the contempt has actually been subsequently filed. I without prejudice to the outcome of the cases, and again, without prejudice to the full content of the affidavits that supports the applications, I believe that it is now settled in our jurisprudence that once an application for injunction to restrain a party, whoever that party is, from carrying out a certain act or restraining you from undertaking anything, once that injunction is served on you, you are required by law, by precedents, because we know justice is dispensed in accordance with case law. I believe the case is Republic versus Moffat also.
Yeah, Republic versus Moffat and others. And the essential part, you quote it in your book as well. I quote, the judge said, "I would be laying down a very dangerous precedent if I were to hold that a party, when served with application for an order of prohibition from the High Court," that's injunction, "can disregard or ignore the said application and treat the court with contempt," quote unquote. That's Justice Saban, 1971. This is the precedent you are referring to.
Yes, and it's been referred to in other cases. I believe the whole idea is that once you are served with the application for injunction on notice, and your actions will be deemed to have deprived the judge the opportunity to pronounce on that injunction, because you have done what you are being restrained to do, thereby rendering the application for injunction moot. You have interfered with the administration of justice because you have now taken the law into your hands and then proceeded to act as if you are the determinant of that application for injunction. And so obviously, if that was satisfied, then it means that the Electoral Commission would have flouted the law. And may be liable for contempt. The only issue in this instance, and there's a decision by, I think, Sir Justice Dennis on that aspect, is which officers of the Electoral Commission will now be liable for contempt. That is the procedural angle that would have to be looked at, because it's been said.
I thought we had gone beyond that. In this case, it will be the commissioners. In my practice, when I needed to cite them, I cited all the commissioners, and they couldn't object to that.
Yeah, that is why I'm saying that it becomes an interesting scenario. That is, I have not seen the application for the contempt.
Okay.
that has been served. And so the officers, and then they prove that.
It is citing Jean Mensah and two of the deputies, Eric Bosman-Asare and Mr. Tete. That's the name, right? Yeah? Tete, Mr. Tete. Yeah.
Yeah. And so it would want to see how it ends up being played in the court, and then the EC federating or going on with this registration exercise. I believe that with all the views that have come up, the EC would do a lot of service to Ghanaians without any political colorization, if there is some consensus on this, to ensure that at the end of the day, what they intend to do, carry out their constitutional mandate, is done within the contemplation of the lawmakers and to the benefit of those that are supposed to benefit from it.
Right. And finally, and very quickly from you, what I refer to as a face-saving thing that they have done, I think last night, their lawyers, as in lawyers for the commissioner, Dr. Eric Asare Bosman, and Mr. Samuel Tete, have written to the lawyers for those who are citing the EC office commissioners for contempt, saying that they are waiving the personal service so that they can hand the documents to the one who is delivering this letter to them. This has come about after a couple of days of some dramatic scenes at the Electoral Commission offices, where without a doubt you can see that they are just running away from being served. And so they are not allowing bailiffs access to come to the premises and serve their officers. Some say this is very bad for a public institution treating a court process in that manner and court officials. What do you say?
Well, I have followed on media, both social media and mainstream, the drama, as we call it, when it came to serving the EC with this contempt application. And like you said, last night, a letter has been written. I have a little bit of challenge. I've not seen the letter and the processes again that have been filed before.
Yeah, I've seen the letter, but go ahead.
Yeah. Okay, but you know, there is a provision in the rules that required that states that a lawyer for a party may write and ask for processes to be served on that lawyer.
That's right.
On behalf of the party. It's in the rules.
Yes.
Now, before you are deemed to be a lawyer, you must have entered appearance on behalf of that party, so that the record will show that you are a lawyer for that party. Now, if you have not seen these processes, you will not be able to have entered appearance. And the letter that was written should be directed to the registry of the court, not the lawyer who files the originating processes, because that lawyer is not the one to effect service. It is supposed to be done by the registry of the court. Now, seeing that this is contempt and it's a quasi-criminal matter, I do not think it may be there in the rules as to a lawyer asking that the registrar should serve. But I think that the practicality of it is very challenging, because this is a criminal matter, and the persons who have been cited for the contempt are required to be personally present in court. And more or less, any processes that are filed in response by means of affidavit in opposition must be filed and deposed to by them. And so if there is indeed evidence that there are attempts to evade service, I think that the lawyers may be, just for the avoidance of doubt, may want to apply for an application to serve by substitution and even make reference to that letter that was served on them by the lawyer.
Oh, but you just referred to the rules, which you are very conversant with. Order 7, Rule 12. Let me read Order 7, Rule 12. Order 7, Rule 12, 2 says, where a lawyer undertakes in writing to accept service of a writ on behalf of a defendant, the writ shall be deemed to have been duly served on that defendant when served on the lawyer. This is what they are saying. Bring it to we the lawyers. That's okay. Stop going to their offices looking for them.
Yes, that is what I'm saying, that the rules provide that means. But then it becomes interesting if you have the situation as in the lawyer has not entered appearance yet, because the definition of a lawyer is somebody who is on record deemed to be the lawyer for a party.
I get that.
The rules. And so I believe that you must have entered appearance first on the record. And that undertaking is addressed to the registrar of the court, not the lawyer who filed the process.
But if someone elects and says, I am the lawyer, then you should presume that they are the lawyer. I think that's the case here.
There are reported cases in this country where a lawyer entered appearance. I think on top of my head, I can refer to Barclays Bank versus Ghana Cables, 1996, 1997. A lawyer entered appearance, participated in the process. Summary judgment was obtained against the party. The party came back, went to the Supreme Court and said he was in jail. He never instructed the lawyer. And the court set aside the processes.
Interesting.
And so yes, even though it is doable, the rules accommodate that. I mean, it's because of the peculiar nature of and sensitive nature of these things.
Because there's a potential prison term.
Exactly.
That is a potential prison term if it is found that they are actually guilty of contempt. Thank you very much, Bobby Banson. Bobby Banson is a lawyer and also an author of legal texts, civil procedure in Ghana.